temporary custody of a child. What happened, my lord, the matter before your lordship is relating to allowing section 12 application, my lord, where it was directed to visitation and also allowing the father to file an application for periodical custody during vacation. That was subject of challenge before your lordship. What now we are facing the problems of now each and every before vacation, father used to file an application and enter vacation granted custody. The court is of the opinion, until that order remains, I cannot do anything. Father is entitled to get the custody. So mother being the mother, neither vacation nor holiday, not getting.
You have the custody for the remaining period, Mr. Raj.
Mother, that is why, mother. That is why, mother. Sometimes it should be given to the mother also. Who is?
You are getting the entire time except the vacation, Mr. Raj.
Now the son is not willing. But this is the problem which you are facing, my lord. Kali.
Where it is appearing?
It is appearing as in the monthly list, my lord. 1230. I did not mention before lordship before the operation. Now they have filed another application for enter puja vacation.
So they have filed an application.
Yes, that application.
They have filed an application before the trial, Judge.
Yes, on basis of this order. The father has granted liberty to file application for periodical application for temporary.
Who is appearing for the other side?
First time, my lord. I am only praying for that portion. If your lordship wants, I can serve on the other side. I am only. My husband will get 3 days, at least 2 days for mother who is looking after the child for the entire. What he is doing is enter vacation, file an application, take it. This is the problem.
All right, hand over the seat. My lord, have you mentioned that urgency, Mr. Rai?
Oh. This was a.
Please mention.
My lord, with regard to item number 57 of today's list, my lord. My lord, day after tomorrow, the date has been fixed before the learned trial court, my lord. My lord, payment of first installment, my lord, in respect of an application under section 2, my lord, this matter was heard.
Under section 2.
Section 2. 7 of the West Bengal.
Yes.
This matter heard by your lordship, my lord, last week, my lord.
Yes.
My lord, if your lordship kindly take up this matter, my lord, today, my lord.
Now, what will happen? Deposit the installment.
My lord, I have challenged that order, my lord, by this.
Right.
My lord, that application has been heard by your lordship.
Let me see how far I can proceed today.
My lord,
it is fixed when?
Yes, my lord.
It is fixed when?
My lord.
For the learned trial judge, it is fixed when?
My lord, within time, my lord, I have this.
What is? Let me see how far I can proceed.
Your
Yes.
lordship was pleased to grant leave to file without the certified copy, my lord, 2 civil revision applications yesterday. My lord, because of the stamp punching and all, my lord, it could not be done yesterday, my lord. The endorsement is today.
My lord. 7th of August 2025.
All right, let me see how far I can proceed. Yes.
My lord. Those 3 issue applications, your lordship was ready and lordship admitted for that. On the last Friday, it was but the bar, it could not be taken up.
Applications.
Review application, your lordship was
Yes. Let me see, I will fix another date.
Under extreme urgency, my lord, I have a lordship's kindly, my lord, to mention item number 877 of the comment. My lord,
For what?
partial, my lord, for advertisement, partial to your lordship direction, my lord, passed earlier.
Why did you not mention yesterday? Yes.
My lord, under completing circumstances, I am mentioning this matter of expeditious trial.
Please wait for some time because if all the matters are upgraded, no motions can be taken.
Under complaining circumstances, I am mentioning this matter of expeditious trial for upgradation of item. My lord, the next date of the trial could be 10th of the September, my lord.
Nothing will happen. Participate on the next date.
Extreme urgency, my lord, I am mentioning item number 477 of the monthly list, my lord. My lord, here the urgency is this, my lord. My lord, the learned court has directed me to pay, my lord, occupational charges, my lord. That is too high, my lord. And your lordship, the next date is on Monday, my lord.
Nothing will happen.
Kindly, my lord, kindly,
Yes.
my lord.
Type copy of the. What do you want? Leave to file a civil division application with a type code. You don't have the server copy. Oh, yes.
I come back at 2, my lord. This matter was hard.
Let me see. Yes.
Friday, this matter hard, my lord. By
Yes.
your lordship.
No. Yes. Call the list. No. Yes.
Opposite parties.
কিসের জন্য এটা? জানি না। হ্যাঁ? ও it has been pointed out that there is a typography. Yes, what is the correction?
Person can be disposes, but it should be any person cannot, the person in the second last page.
In which paragraph?
My lord, it is highlighted, my lord, in the second
Oh.
last page of your
Also
lordship's
that a
order.
person can
It will be, my lord.
it has been
for the petition. This matter was supposed to appear in the monthly list of July. It didn't appear July, August.
in the order dated
My lord, I am for the petitioner.
yes.
My lord, there is a typographical mistake from the cost title.
It has been pointed out that there is a typographical error in the cost. Matter.
Item number 5. Item number 6.
I am for the petition. At my instance, the matter has been listed.
Yes.
My lord, urgency is, my lord, this is a college. My lord, because
Sir,
of, my lord,
it
in
was
this matter-
heard it was directed to retain its
Yes,
position
yes,
in the list.
yes, but my lord, difficulty is what I am,
This matter, my lord, Mr. Subishan appears for the, my lord,
The order is also there.
yes, yesterday I told
My lord,
Mr. Sannat.
it is a
Yesterday
long
I
matter,
talked
my
with
lord.
Mr.
It is
Sannat.
a long matter, my lord. It will be.
No, it is not.
Audit.
My lord,
So Mahato, please come after the vacation.
my lord,
Yes,
kindly
my lord,
consider
kindly
this situation.
consider
Why
application.
my lord has allowed my mention. My lord, because of
I have
this.
allowed to see what is the
Yes,
urgency.
yes, urgency.
Because
My lord,
now I have seen the orders.
my lord, I am showing the urgency. What is the urgency? Urgency is, my lord, it is a college. the administration, including admission,
Can you file an
everything has
application,
been,
Mr. Mahato?
but everything has been stopped.
You file an application for that.
She is disturbing money.
Can you file an application for that?
He is always disturbing money.
Sir, he has a right to make his submission. Considering his prayer, I have directed to let him file an application.
Application for early hearing.
That is up to you what application you will file.
But the main matter may be disposed.
That,
If
Mr.
your lordship,
Mahato, I will consider that. It's a contested matter.
if your lordship so
Before
desire,
the
but I,
vacation, it's not possible.
what I'm humbly submitting before your lordship, kindly fix a date in month of November.
All right. Please come after the vacation. I will consider.
Yes. Before that matter, I mentioned, before this time, I mentioned earlier, but it has not. If your lordship kindly fix a date in November so that both of us, my lord, will get
Mention after the vacation, I will fix that. Please remind me. I will consider that. Yes. Call the next matter.
Item number 7.
7 is my application, my lord. That appear to study.
Yes.
My lord, your lordship has passed an order, my lord, which was assailed by my learned friend, my lord, that I had filed an application for, my lord, dissolution of marriage, my lord, and it was withdrawn without, my lord, praying for liberty to file afresh, my lord. My lord, if you lord,
What is this? Why it is appearing under the to be mentioned?
Yes, my lord, because I had obtained certified copy, my lord. My certified copy says, my lord, that there was a specific prayer, my lord, with regard to filing of the matter afresh, my lord. Which, my lord, whereas, my lord, the learned senior friend, my lord, if your lordship kindly take pen to come to page 19 once, my lord.
Page
19 of the application of your lordship.
19.
19, my lord.
Yes.
My lord, this is the certified copy which my learned friend has, my lord, enclosed.
Yes.
So the last 3 words, my lord, দরখাস্তকারী fresh file করবে না. Has your lordship got it, my lord?
দরখাস্তকারী fresh file করিবে না.
Nah, and my lord, your lordship kindly take note of the name, my lord. DEBESH, Dibesh.
Yes.
Yes. Now your lordship kindly come to the next page.
Yes.
Affidavit part. পুনরায় fresh file করিতে করিব, my lord.
করিব ইহা
Yes.
সত্য.
ইহা সত্য করিব. Now if your lordship, my lord, kindly take pen to come to, my lord, last 2 annexes of your lordship's brief, my lord. This is a certified copy which I had obtained,
Yes.
which says, my lord, the last 3 words, my lord, fresh file করিবেন.
Which page? Certified copy of the
My lord, second last page of certified copy, my lord.
করিব. No, page 11. No.
My lord, the page, my lord, it is 30 and 31, my lord. It is not marked, my lord.
Page 30 and
My last 2 pages, my lord. Not marked, my lord.
certified copy.
Yes, my lord, certified copy.
Yes.
Fresh file করিবেন. Your lordship kindly sees, my lord. The specific prayer has been made by me.
No, in the supplementary affidavit you are saying.
Yes, my lord. The application.
I'm looking at the civil division application.
No, my supplementary affidavit, my lord. The last 3 words, my lord, fresh file করিবেন.
দরখাস্তকারী পক্ষে মোকদ্দমা উইথড্রয়ালে দরখাস্ত মঞ্জুর করিয়া বাধিত করিবেন. Fresh file করিবেন.
Ben. And lordship kindly take note of the first title, my lord. Dibesh. DIBSH. The spelling, my lord.
Yes.
And my lord, the affidavit also, my lord, I have spread, my lord, for liberty, my lord, filing afresh, my lord. Now, my lord, the certified copy which my learned friend has obtained, my lord, where the word Koriben is missing, my lord. For that reason, I am before your lordship, my lord. Let the record be called for, my lord. I don't know which certified copy is, my lord, depicting the actual scenario, my lord. And your lordship has passed an order which is transpiring at page 26 of your lordship brief, my lord.
So how are you prejudiced? He's withdrawing the matrimonial
No,
suit.
my lord, because I have taken a liberty, my lord, to withdraw and to file afresh, because, my lord, the filing has been debarred, my lord, by your lordship.
Only,
Because, my lord,
without any limit.
yes, my lord, that is, my lord, which is, my lord, pinching me, my lord. For that reason, my lord, I have taken the endeavor, my lord, to obtain the certified copy and before
Yes,
your
what do you say?
Before lordship passes any order.
Please use the microphone.
Micro.
Before your lordship passes any order, my lord, I would like to submit that your lordship give me a an opportunity of filing an affidavit in opposition for this sitting, specific allegation has been made against my client.
All right.
Your
Uh,
Lordship, kindly give me the
let-
opportunity
yes.
so that I can divulge every fact.
Yes, call the next matter.
Item number 9.
And my lord, it has already been disposed of on 29 July 2025, my lord. Suddenly it came in the list today, my lord. We don't have any
First,
idea, my lord.
It has been pointed out that there is an typographical Yes. Okay. Same order. Typographical error in the cost title of the order date 22nd of July 2025. The correct cost title shall be. Yes, next.
Item number 11.
Yes,
Some urgency in this matter.
yes.
My lord, this is a matter where the opposite parties have filed a suit claiming to be the.
No, this you have mentioned for release.
My lord,
Yes,
because
my
of
lord.
what?
Ashwin. This matter was mentioned yesterday for taking up this matter out of turn. To stop, in view thereof, this matter was directed to appear under the heading to be mentioned today. To stop, the petitioner is you are for the opposite party.
Opposite parties, my lord.
The learned advocates, no, the parties are represented by their respective learned advocates. First up, it appears from the presentation form that the civil division application was filed on 14th of August 2025. First up, the date of listing of the said application was mentioned in the presentation form as 25th of August 2025. Accordingly, the civil division application appeared in the list on 25th of August 2025 and the same was taken up for hearing on 25th of August 2025. However, on that date, an adjournment was paid for by the learned advocate for the petitioner. Accordingly, the hearing of the civil revision application was adjourned by an order dated 25th of August 2025. However, this matter was mentioned citing urgency. The learned advocate appearing for the petitioner. No, no, since the
Railway matter called locker. I have served the collector Howard. Mr. Vaman Banerjee appeared
yes, where is Mr. Oyan Banerjee?
and he has a service.
Yes, Mr. Ghoshal, Mr. Banerjee was there. Mr. Rai, can you ask any of your juniors to inform Mr. Banerjee?
Of course, my lord should hear him, but of course, Mr. Banerjee should be here. But he didn't raise any objection.
No, but he has to because
It has nothing to do here. Locker is only the locker matter.
I appreciate that. I'm passing it over. Mr. Rai, can you ask him to come at 12? Ask Mr. Banerjee. Mr. Ghoshal, can you come at 12?
I shall come.
12.
I am at your lordship's highness, sir.
Thank you. Yes,
I wanted to let it be disposed of.
Yes, let Mr. Banerjee come.
The highest portfolio paying, irrespective of value.
Let me see.
I'm informing him, my lord. Sir,
Yes.
একটু বসুন, আমি যদি হয় আমি এক্ষুনি আসতে ইয়ে করেছি।
Not now, ask him to come because he might be somewhere else. Ask him at 12. Yes.
Item number 13.
এইগুলোতে দেখুন এগুলো কি আছে, এগুলো সব ট্র্যাক রিপোর্ট বার করা আছে তো সার্ভিস হয়েছে। Most of them have been served or the rest
What
returned
is this? Extension.
extension for the purpose of extension.
Most of them have been solved and some,
It appears, my lord, service could not be effective.
yes, you are appearing.
Oh,
I have to ascertain, just now that I have been informed that
Now you have been informed you are appearing.
now that I have to ascertain for whom that I am appearing, that
You can ascertain, you file your wakalatnama. Please see for whom you are appearing so that it can be.
and this is the evidence service.
I'll fix the date after vacation so that
The
Your Lordship. Your Lordship, I am for the petitioner. Your Lordship, this is an application under section 227, praying before your Lordship to set aside the order dated 18/6/2025 passed by the learned civil bus junior division. Your Lordship, the brief facts of the case is that the petitioner is a widow of the appeal order. Your Lordship kindly comes to page number 71
71.
of the running page.
You have not filed the certified copy.
No, I have filed. It is there with me. Yes, it is there. I have filed. It is.
How have you paginated page 71? How can you paginate that?
Your Lordship, just for the convenience of your Lordship, the Xerox.
Touch the certified copy, sir.
No, I have not. I have not mentioned on the certified copy anything. I got the Xerox of the certified copy. For the convenience, I have attached that.
18th June 2025. This order you are challenging.
Your Lordship, let me explain in the nutshell. Your Lordship.
This is an order ad interim injunction was allowed on an application under Order 39 Rule 1 and 2. That is an appellable order, sir. That is an appellable order. Revision is not maintainable.
Why I am before your Lordship? There is apparent error in this order.
You are not being able to follow me. So please consider Order 43 Rule 1 Sub Rule R. This is an appellable order. Revision is not maintainable. You file an appeal.
Only my humble submission before your Lordship is here the petitioner. Here they have filed. Your Lordship kindly comes for a moment to.
Sir, please paper an appeal. That's an appellable order, sir. Please consider Order 43 Rule 1 Sub Rule R.
When there is subject to the correction by your Lordship, I am not going to waste time. Your Lordship will kindly appreciate when there is apparent error in the order. I am only
Appreciate that.
I am only limited to that portion only.
Cannot be
Because-
done.
Because I was. I will not.
Appeal. I cannot go into the merits, sir. Please consider that. Please prefer an appeal. You have a very good case on merits. Prefer an appeal. This application under Article 227 of the
I am the petitioner, lordships.
No, for him.
Yeah, I am the dependent respondent petitioner before lordship.
Defendant respondent petition, yes.
The injunction order is granted by in the suit filed by the plaintiff lordship, declaratory suit, and in the case lordship, identity order injunction was granted. We challenge this order in the appeal lordship. Appeal also affirm this order of this. Then we file this division application lordship.
I'm directing the trial court to decide the injunction application.
Injunction order.
Injunction application, I'm directing the learned trial judge to decide the injunction application. Because there is no scope, both the courts have rejected the ad interim prayer. So urgency. Yes.
So before disposing matter, kindly allow me to file one documents for supplementary affidavit to annex the documents.
What documents? What do you do?
They are claiming on the basis of title deed lordships. We are also claiming on the basis of the registered deed lordship.
Yes.
And we are in position on the basis of the record of rights. Record of rights in our favor lordships. But they are not recorded in the name of record of rights lordships. But the learned court lordships passed the injunction order in favor of the plaintiff lordships without considering my record and the deed lordships. The dispute to deed lordships. So kindly give me leave to file
That document cannot be looked into because this is a civil division application arising for an ad interim order. I can only look to the documents which were before the learned trial judge. That is why you can rely on those judgments, documents before the learned trial judge.
I am in position.
I'm directing the temporary injunction application to be disposed of. What is the next date fixed in the trial court? What is the next date fixed in the trial court? Have you entered appearance in the trial court?
Yes, lordship.
Yes. What is the next date fixed for hearing of the injunction? Have you filed the written objection? Have you filed the written objection?
Yes, lordship.
All right.
After considering the written objection, lordship, the injunction order has been rejected, lordship.
What are you saying? This is ad interim you said?
No. Injunction order granted after considering the hearing of the injunction order.
Show me the trial court's order.
Yes, lordship. Trial court.
Show me the trial court's order. Where is the trial court's order?
Yes, lordship. It's 27.
You did not file any document. You did not appear before the learned trial judge. What can be done?
Subsequently, we appear and we file written objection, lordship.
When?
Page, lordship, 28.
Page 28.
Yes, lordship. And
no, that is the written statement.
Thereafter 30. Page 30.
When did you file this?
Fourteen 3/2023, lordship. The top left hand side top.
But it has been recorded that you did not appear to contest the injunction application. That's the recording. And it was also disposed of ex parte. You did not appear on the date of hearing.
Initially, I did not file this application. I paid time.
Then
subsequently.
Then,
but in the appeal court, lordships.
Please give me a minute. trying to show?
Lordship, the deed from which my the father of the Mapiji Lordship, he got the ownership Lordship in the year 19
Ismail Sheikh, you are claiming title from the heirs from the heirs of
Ismail Sheikh. He is the owner of the 50%.
Yes.
Lordship, this is their case. My case, Lordship, one Kadir Bayan and Lolit Bayan are the owner of the entire land Lordship. Thereafter, they, by virtue of the registered deed on the 1947, transferred their share in the name of Ismail Sheikh. After the death of Ismail Sheikh, Lordship, Majefur Sheikh, he became the owner. And his
as heirs of Ismail Sheikh.
now, after death of Majefur Lordship, we became the owner, and the plaintiff we gave execution of power of attorney, which the transfer this land in favor of that.
No, according to your case,
Yes,
the property belonged to Kedar Bayan and Lolit Bayan.
Lolit Bayan.
Thereafter, by way of an exchange, they have transferred in favor of
Ismail Sheikh.
in 1947.
Yes, Lordship.
Now, from Islam,
After death of Islam Sheikh,
yes,
his
his
son Majefur
inherited the share.
Yes.
So, when did Islam Sheikh die?
Date of death.
You don't know. That you don't know. And
After death of Majefur Lordship, we are the legal heirs from whom
that is a different thing altogether.
Yes,
But Islam Sheikh transferred this in exchanged this in 1977.
No, they say,
Heirs cannot have their share.
Lordship, they stated Lordship, Mujaffer transfer this land.
Sir, your claim
Yes.
is to Ismail.
Yes.
Ismail during his lifetime, he exchanged that suit property, and so the heirs cannot get that
Lordship, that deed is required to be placed before Lordship.
in the hearing.
Lordship, but still we are in Lordship.
Maybe
Lordship, record of right. Some presumption values Lordship.
record of rights cannot create any
But
title.
without consent, Lordship.
You did not place that. Show me that you have placed the record of rights before the learned judge of the appellate court. Show me.
Now we raise this.
Maybe this application. Yes,
My lord, I am for the petition, and my lord, item number 16, 17, and 18 should be heard analogously.
yes. What is
Because-
this matter?
My lord, this is a petition for expeditious disposal
Expeditious disposal
of suit pending since 2001.
that is suit number 6 of 2020.
Title number 174 of 2021, 2001. It's CO 3120.
No, this is CO 3112. In this CO 3112, in which suit you are paying for expeditious hearing?
All the three suits. In this suit, it's titled suit number 77 of 2021, which is latter
27 of
2012. 2012, which is latter
certified copies of 1013 of 2016.
My lord, its registration number is 1013 of 2016. The suit
Yes.
number is 77.
What do you find suit number is 77?
My lord, latter it is changed to suit number 33 of 2020. But the suit is pending since 2012. My lord, P3 page 25.
1013 of 2020, it has been again renumbered as 33 of 2020.
Yes.
This application under Article
My lord,
17 is, what is the suit?
no, this is also
What is the number of the suit?
155 of 2015. which is renumbered as 6 of 2020. Along with the title suit, it's a suit for defamation and
What happened to the injunction application?
they did not maintain the injunction application and they.
No, has it been disposed of or it
No,
is pending?
it is pending. It is yet
Pending.
pending. Yes.
What is the next date fixed for hearing of the injunction application?
All the 3 dates were 1st September 2025, but there was.
The injunction application
Yes.
for hearing of the injunction application.
Yes.
This application under Article 227 of the Constitution of India is at the
TS number 174 of 2001. Injunction is there, my lord.
now it is
They're praying for
033 of 2025. What is the present suit number? No. 174 of 2001.
yes. Still 174 of 2001. Injunction has been extended on the last order.
Have you taken steps for substitution? Have you taken steps for substitution?
The injunction is still pending.
Madam, have you taken
No.
steps? Then how can the suit proceed? You are fortunate that recording abatement has not been recorded. This application under Article
difficult. All the three matters should be before one bench.
That you have to take steps, madam, before the learned trial judge. Cannot be done from here. Yes.
Grateful, my lord.
Number 19.
Yes.
My lord, item number 19, 20, 21, and 22, my lord, connected matters. My lord, I am appearing on behalf of Cholamandalam Investment and Finance Company, my lord. My lord, my learned senior counsel is not present. He is outside the court, my lord. May my lord may fix the matter after puja vacation.
What order are you challenging?
My lord, please, my lord, fix the matter after puja
What order
vacation.
are you challenging, madam?
My lord, my senior counsel was arguing, my lord.
Maybe
this
that
matter.
cannot be a ground. You are the advocate on record.
My lord, my advocate on record is not present, my lord.
Why should not be fixed for all the hearing? Ashun, this application under Article 227 of
Well, 20, 21, 22.
same matter. Madam, why in these matters why are you paying for time?
My lord, my senior is not
Maybe
here.
you are here, you are the advocate on record.
My lord, may I pass over the matter, my lord, 20, 21, 22.
Passover, yes, come at 12,
Okay, well, much obliged.
20, 20, 21, 22, Passover, about Ashmara. Yes. Next.
My lord, praying for a short Passover. Senior counsel is in court number 8.
You are the advocate on record.
No, no, sir. No, sir. No, sir.
Not the advocate on. Let me see. What is your name?
Seema Thakur.
This application under Article 227 of the Constitution of India
This is for expeditious hearing, my lord.
So Bhattacharya, you are moving expeditious hearing matters.
Oh, no. My lord, I was before Justice Vijay Pal, my lord.
Since the junior was moving, I was minded to allow. Since you have come, now
No.
I think I have to change my order now.
I have taken back. I'm really taking back. It had-
This application under Article 227 of the Constitution. Yes, call the next matter.
Great. My lord.
Yes.
My lord, I am appearing on behalf of the defendant petitioner, challenging the order of injunction passed by the trial court, my lord.
Challenging the order of
Injunction, my lord.
passed by the learned trial judge.
Trial judge, my lord.
Is it a revisable order?
No, my lord, this is applicable order, my lord.
Why
Actually,
have to file a revision?
at that time, actually, district judge court was lying vacant, my lord.
Now, district judge.
Now, just over phone, I just know that he is now joined, my lord.
Ashwin.
Petitioner, your lordship.
Yes.
This is an application for expeditious disposal
Of what?
of title suit number 145 of 2010, which has been subsequently renumbered as title suit number
What is the
75.
stage of the suit?
On the last occasion, the suit was fixed for arguments.
Suit fixed for argument, even then you are coming, sir.
No, yes, lordship, there has been serious purported misconduct on part of the defendants.
This
On four
application,
occasions,
this application under Article 227 of the Constitution.
It's come to be success.
Ask Mr. Banerjee to come at 12. It is going on. It will also go on after 12. At 1, when he will be free? Mr. Ghoshal, can you come at 1? Yes.
Number 26.
Yes.
This is also an application for expeditious disposal, my lord. Appeal was at the behest of the petitioner Ashish Kumar Mullik, my lord, under section 34 of the Arbitration Act. That is
Mr.
pending.
Chakraborty will not leave anything for your
No, my
junior.
lord, under compulsion. Your lordship kindly seize the. I had to.
Yes.
No, my lord, section 34 appeal that was pending since 2016, my lord. It is
What is pending?
section 34 application under Arbitration Act, my lord. Appeal. My lord.
Section 34 is
Yes.
pending.
Yes, my lord. And that is for 2016.
From
And since,
2016.
yes, my lord. And since 2022, it is running under the heading hearing. All the things are complete, my lord. My lord, to be very honest, my lord, sometimes the court remains vacant, sometimes transfer, my lord. But on successful
Now the
occasion,
court is presiding officer
yes,
is
yes, my
transferred.
lord. And on the last 3 occasions also, it was adjourned.
This application under Article 227 of the
28, my lord, I am for the petitioner. My lord, we have filed before the learned court below one case under order 21-97 for adjudication of my independent right, whatever it may be. That application is pending for disposal and the evidence of the parties are over.
Evidence over.
Evidence
No,
over. Sir, let me submit.
ঠিক আছে
Evidence is over, date is already fixed for argument. At that stage, one application for recalling of the OPW1 was filed for marking certain documents which are not even in the pleadings. And that application was allowed, being agreed, we are before your lordship. Rather, the fact remains that I insisted the learned court to issue summons upon the Calcutta Municipal Corporation to bring the relevant records to show that my name is recorded as a tenant because I have exhibited certain documents. They opposed. At that time, they opposed. But subsequently, after closure of their evidence, cross-examination, everything, my evidence, everything, the date is fixed for argument, they filed this application. Be that as it may, this is not in the pleadings also that we have issued a RTI letter. First, the pleading is to be amended, nothing.
Where is the application for recalling?
Page 41. Kindly see. No diligence is there. I am relying on the apex court judgment as held by our court also, my lord. I am not saying that witness cannot be recalled, but there are cases when it can be done. Kindly see. 2nd June 2025. After this episode, after my application for summoning the witness is rejected, and this is also recorded in the order also, in spite of that the learned court as a routine work allowed the application for recall. So I have to counter, if the documents are exhibited, I have to counter in my pleadings, nothing in the opposition. Let them disclose first the documents in their opposition. Why it was applied at the belated stage? Nothing has been stated. No due diligence. I'm very much, my lord, relying on the judgment delivered by our court, my lord, reported in 2025, volume 1, ICC, page 532, referring to the apex court judgment.
Yes, what is the decision you want to rely upon?
My lord, the first decision of our court, my lord, reported in 2025, 1 ICC, page 532, referring to the apex court judgment, reported in 2011, volume 3 ICC, and 2016, volume 3 ICC, Supreme Court, page 232, as well as the other judgments of the apex court 2000. Kindly come to para 4, and the facts are similar. To contend that for the aims of justice and complete adjudication of the matter, courts have discretion to recall witness for further examination. It can be reopened, and this power is discretionary. Then para 8. It is true that in appropriate cases, witness may be recalled. It is clarified by the Supreme Court of India, para 8, that power is discretionary and should be used sparingly in appropriate cases to enable the court to clarify any issue or doubt it may have in regard to the evidence laid by the parties. It is also clarified that this power is not intended to be used to fill up omissions in the evidence of the witness. the principle is reiterated in Ramroti's case, that basic purpose is to enable the court to clarify any position. The court is not feeling, the court is not saying, the court can recall after omission of order 18 rule 17 capital A, the court can, but the court has to satisfy that yes, this witness is required. There is no such findings in the judgment, impugned judgment. And not only that, my lord, this is not in the pleadings also, they are affidavit in opposition. Let them amend the fact.
Show me the evidence of OPW1.
Evidence of the OPW1, my lord, sorry, my lord, I can produce it by Monday, my lord. I can bring it. I have not annexed. I have obtained the certified copy. I can produce.
Yes, Mr. Chakravarti.
May
what
I,
you said.
one Dasgupta family, Dasgupta, were let out the entire premises. Entire premises was let out to one Sanjeev Dasgupta and others. Suit for eviction was filed in all courts. The reasonable requirement was ground was proved. Notice ground was not the defective notice was there. Matter went up to the Supreme Court. Supreme Court ignored that. The purpose of the notice was to give some time to vacate. So then my lord, the Supreme Court stated, asked the defendant tenant as to how much time they require to vacate. Then they stated that they will vacate by December 22, excepting one room which they cannot deliver.
In my
Yes.
possession.
Because that has been sublet. Thereafter, and by the said degree, we have been given opportunity to take steps in accordance with the law for eviction of that room. Well, rest of the room we got possession, but this room was not given possession because he is occupying the same. We, my lord, execution case file, the bailiff was registered. We filed police application for police help. They filed application under order 21 rule 99 order. Well, in their application, they have at least 4 or 5 witnesses they have examined, my lord. Several times he came in division. We also, my lord, opposed. My lord, after the evidence of court witness is over, my lord, they again prayed for summoning to the Kolkata Corporation. My lord, the court asks, why for you are asking for another witness? He stated that we want to file one document. My lord, this document, my lord, this document was produced and court said, no, you do not want to issue someone, you keep that document, the document will be exhibited. My lord, that document, by that document, he is trying to say that corporation recorded him as a tenant, and my lord, and that document was exhibited. I was not given, my lord, opportunity to cross-examine the same. Well, after that, my lord, I made an RTI application to my lord to get an information as to whether any notice was issued to the landlord before recording the name as a tenant, whether any hearing was made. The corporation replied, no notice was issued to the landlord, no hearing was made, and according to the own application made by this Ranjit Maji, his name was recorded. That's why, my lord, this necessitated for me, because after he also, Mother Ranjit Maji, the petitioner in the Miss case, also during the time of his examination did not produce the document. Several witnesses also, they never produced the document. After 4 or 5 witnesses over, he, my lord, asked for production, summoning, and court, my lord, without, my lord, issuance of summon, without, my lord, any evidence, without giving opportunity of hearing, my lord, recorded this. So that's why, my lord, I had to apply. My lord, kindly see what I am wanted to. This is the, my lord, this only, my lord, the 2-3 questions. This is my RTI and reply.
Where is your application? It has been annexed.
Page
Application
41.
for recall.
Page
Yes.
41.
And my lord, I have annexed, and my lord, my examination in chief of the on recall has also been made. He will only to cross-examine.
No.
Yes.
We intimated that the matter is appearing in the list before your lord.
Yes. He intimated. Examination of chief is already over. Only cross-examine, my lord. And what I am, my lord, he is producing document only, my lord. To my lord, I have only this thing. My lord, 2022, my lord, the degree was passed. How he is, my lord, he can, he's saying that for 15 years I am over there. And by his own application, he has.
Sir, Chakraborty, where do I find that these those letters or some documents were exhibited on his
From the order sheet, my lord, from the order, from
where-
the impugned order, your lordship will find.
impugned order? Please show me that.
Yes.
Exhibit 4.
Lord, kindly see impugned order.
Exhibited a letter.
Yes.
My lord, kindly see, it is, my impugned order, it is submitted that the OP has not mentioned about any such reply in the RTI. RTI application is pleading. Therefore, the document sought to be exhibited by the OP is beyond the pleading. If it was further submitted that the OP raised objection upon the petitioner wanted to issue summon that upon the assessor collector KMC as his next witness in connection to the letter marked as the petitioner was not allowed to call the said official as witness. Therefore, petitioner prays for rejection of the petition filed. Well, summon was not allowed. My lord, instead the document was, this document, my lord, has been exhibited. And my lord, this, my lord, compelled me to file application for RTI, and only this, that he is.
Are you relying upon any decision?
No, my lord.
All right.
And this is the
Coming after 5 minutes. Yes, what is that?
this is the
My lord, kindly see the document they have.
my application for police for adjudication of my
Every case
nowhere it
depends,
is stated.
depends upon the facts of the case.
All right,
No,
I'm coming after 5.
Yes.
Yes.
Evidence. Another point, my lord, 10th of May 2024, we have discovered this, disclosed this document in our affidavit as to evidence. 10th of May 24.
You have not produced that evidence.
Kindly see.
You have not produced that while you are giving your examination. Your examination was made.
Waited for 1 year
What
to
is
issue the letter.
Yes. What document is in your pocket?
This is mine.
Yes.
In May 24, and you waited. At least I am entitled.
Yes. No.
You have not. You have not disclosed.
You are an unauthorized occupant.
Maybe.
Yes.
I am not suffering any degree.
Okay.
You got the degree against some person.
All right.
Go on fighting.
My lord has heard both parties.
Apex Court held that
Whatever reasonable
you have
order.
to take legal action.
My lord.
You have that KK values from his order, judgment, 2011, volume 11 SCC. Have you got that?
That is not here. That is quoted. That is quoted. I can produce it.
Quoted I have seen. Do you have that decision? Yes or no?
Yes. I can file it. I can produce. It is in my file also. Chamber file.
My lord,
But you have not brought here.
Every case depends upon the facts.
Case
Unless
says
there
that
is
the court
factual
can,
basis.
even after closure of the argument. But in rarest of the rare case,
Yes.
if it is pat on the point, you have to satisfy. But there is nothing in the petition for recalling. That was an application under section 151. Apex Court dealt with and order 18 and the effect of order 18 rule 17 capital A. It is the prerogative of the court. If the court finds for effective adjudication, but there is no such findings that this document is required to be brought for effective adjudication.
Not a single rain receipt could be produced.
Maybe.
No, not a rain control challan. No, case before the rain controller that in spite of receipt of the rent, someone. Yes.
Merit of the matter.
Yes, everything will be considered by the court.
Yes.
ঠিক আছে আমার ডকুমেন্টস
Yes.
আমার ওগুলো দেওয়া আছে
Yes, documents you can take back. Yes. Yes, call the next matter.
Item number 29.
Next, Madam Lord, I appear for the petitioner. Now, your lordship was pleased to pass similar order in another matter. Not
Item number,
29.
what is the similar order?
Lord kindly takes up this order.
What is the impugned order?
Order 39 rule 7 was rejected in a suit for building and rebuilding. Lord, I want that the tenanted property is required to be measured because, Lord, if I want the suit, Lord, I have to hand over the property. Lord, what is the exact nature or measurement of the property? Lord, only the name of the tenant is different and suit.
This is also at the stage of evidence.
Stage of evidence, 25th of
Same
November.
order টা pass করুন। Same order যেটা আছে না একই order pass করুন। শুধু ওই suit number, foot number। The next matter. আর এটা কবে আছে বলতো? মোশনে কবে থাকবার কথা আছে? Yes. Yes.
Number 30.
Yes.
The defendant in a eviction suit is the petitioner before my lord. 7(2) application has been rejected, though it has been filed within time.
Though it has been filed within time. Why did you file section 5 application if it is filed within time?
Section 5, my lord, section 5 was filed. If my lord takes up the impugned order, takes up the impugned order once.
No, no, I'm asking you, if it is filed within time, why did you file section 5
That
application?
was on a wrong advice. If my lord takes up the
Wrong advice.
wrong advice, my lord. If my lord takes up the order,
Yes.
order
When the summons was served upon you,
my lord, the summons was served upon me, my lord. Take the order. My lord takes up page 17 once.
so please give me some dates. When the summons was served
The-
upon you,
Order, there was a directions to appear
give me the dates. When the summons was served upon you,
by order dated 6th of March 2024. Directions was given to serve the issue the summons, and the next appearance date was 22nd of May 2024. We had appeared
22nd of May 2024 was the date of appearance.
date of appearance. If my lord
And
takes
when
up,
did you appear?
my lord, we had filed and we had received.
When
the
did you
summons
appear?
23rd of April 2024, my lord. If my lord takes up
23rd of April you appeared.
23rd of April 2024, Annexure C.
And when did you file that application?
My lord, on that day, particular day, we had filed the section 7(1) and 7(2) petition. My lord, Annexure
23rd of April.
Yes, my lord.
All right, give me a minute. Give me a minute.
Annexure C.
Where is your application for condonation of delay?
My lord, in this petition, there was no petition for condonation of delay.
Yes, yes, that was rejected.
My lord is taking up CO 3273 of 2025.
Yes.
My lord, there was
Impugned
no,
order. The petition under section 5 of the Limitation Act
there
is
was no
hereby
petition for
rejected.
section 5, my lord. There was no petition for section 5. If my lord takes
So
up
that
page,
is this is the impugned order.
that was the, and if my lord takes up page 26 once, Annexure E. Annexure E, page 26, order number 2 dated 18th of April 2024. Peru, my lord, fifth paragraph from the top, my lord. Peru's had considered the petition under 7(1). We had filed it within time, my lord.
But please look at the impugned order
I have
section.
gone through the impugned order, my lord.
So what prevented you from filing an appropriate application before the learned trial judge? I cannot decide it from here
My lord,
whether
we had
it was
filed an
section 5 or
appropriate
not.
application, my lord. If my lord takes up annexes page 37 once, annexure G, my lord. Petition for deposit of rent
how it has been.
So I think I'm giving you liberty, you approach the learned trial judge. Oh, yes, page 38. Please come to
38,
page
my lord.
38.
38 is the petition. It was filed for petition for condonation of delay, my lord.
You are saying no section, no
The
section.
7.1 and 7.2 was filed within time, my lord. This was filed on wrong
Why
advice.
did you file this application?
That was on wrong advice. My 7.1, 7.2.
You are saying you did not file any section 5.
My lord,
This is a
7.1,
section 5 application.
Annexure E is the relevant portion, my lord, page 26, where it has been stated that the 7.1 and 7.2 was filed within time.
When did you deposit the rent for the month of April 2025?
And April 2025, that was the current rent which was deposited.
When did you deposit that?
That was deposited after a month.
Then?
But that was for the current rent.
Maybe current rent also defense is struck off rightly. The learned trial judge has said so. So this is the application, sir.
This is the
maybe 7.2 within time, 7.2.
7.1.
Current rent non-compliance, 7.1 C gone. 7.3 extracted.
Proviso, my lord, the proviso part once a default. My lord, the proviso of
Proviso, sir, it's after adjudication of 7.2.
7.2.
So what you are trying to rely upon of Devashish Pal paragraph 17, now the Supreme Court has held no, that will not apply. That's the decision delivered on 13th of August 2025. That's gone now. Ashun, this application under Article Same.
Same order would be passed, my lord, the parties are different, my lord, that.
Parties are different. Month is also same. April 2025. Same order. To the suited number
Right. That has come up against an order passed by the learned additional district judge first court at Kollani, my lord, rejecting, my lord, the prayer made by the petitioner for adjournment. My
for
lord,
adjournment.
only adjournment because what has happened, my lord, just briefly by indicate. I will take 2 minutes of
You are
your
the
lordship.
defendant.
I am the defendant. My lord, I am contesting.
Sir,
Lordship,
in a suit for
in a suit for, my lord, it's a probate proceeding, my lord. A application has
an
been filed.
objected to the
I am objector, my lord. I am the son. My lord, the father has bequeathed the property, my lord, in favor of
how
the
many
mother.
adjournments you have taken?
My lord, what has happened, my lord? I must be candid, my lord. My lord, the learned trial judge, my lord, passed a decision order. But I have nothing to.
Then that's the end of the
but-
matter, Mr.
My lord, what has happened, my lord? The advocate, my lord, who was conducting the case in the court below, my lord, on the last 3 days, my lord, he has not appeared. But on that ground, my lord,
Proceed against the learned advocate.
my lord, I cannot. But
Why?
it's my lord, my lord, kindly give me one opportunity, my lord. I assure you, lord, if I fail, my lord, I fail. My lord, I will bow down to your lord. Kindly give me one opportunity.
How much cost you are willing to pay?
My lord, I have been directed
Got that your concession of cost, and I will
my lord,
allow.
because my lord, it's a, my lord, just my lord, 1 minute, I will briefly indicate the fact. My lord, the testator,
The facts. How much cost? I
like
want.
2000 has already been awarded, my lord.
1000 is nothing.
My lord,
How many zeros
my lord,
after that?
I am right now.
How many zeros after that?
3 0 is sufficient, my lord. After 2, my lord, 3 0 is
2 will be kept intact, no difficulty. How many zeros after that?
my lord, your lordship kindly consider my predicament, my lord. My lord, I am, my lord, because you were a learned advocate. He said I am not ready. He has not appeared. But what can I do? I have sought
Cross examination of PW1 closed.
he has been recalled, but he has recalled because on the ground, because the very pertinent question, my lord, has arisen because the testator, my lord, who has executed, he has got no mental capacity. But on that count, my lord, I want to, my lord, ask certain question. My lord, that only 2 date, my lord, I have missed. One date, my lord, there was no regular PO. So that's why, my lord, could not be taken up. My lord, the second date, my lord, the learned advocate was absent. But that's why, my lord, I had no other option but to pray for adjournment. And the learned settled me with
The order impugned.
Saga, my lord. I'll tell you, lordship.
It's a never-ending saga. I was
I'll tell you,
talking to
lordship,
Mr.
what has
Manager.
happened. 5 minutes, I'll finish it.
Again, what have you done?
I have not done anything, my lord. Your lordship recalls the learned trial judge had directed that because he has interacted with the child, he found that the child was not in a mental condition and should be sent to a psychiatrist. We had taken it to a psychiatrist. The psychiatrist was to give a report on a certain date, on the returnable date. We gave
No, there was previously a report obtained.
that
Thereafter-
only. That only. I'm just giving you, lordship, just the backdrop
Yes,
to
yes.
indicate what has happened.
So what is the impugned order?
The impugned order is he has now disregarded. I'll tell you, lordship. Not when that child psychologist report had come, we had given.
So I think if I faintly recollect, I allowed you to produce that by
Oh,
filing an.
happened. Yes. So when we could not produce it, although we had it, there was some miscommunication. We had given a time petition saying we had taken the child on 4 dates, but the report is not ready. Then he passed the order that because I had failed, the child should be taken to Bombay. For 48 hours stayed with the
That
father.
happened.
Then we challenge that and come before your lordship. Your lordship directs that no, because the child report is there, the court once thought it should be examined. I'm sending it back. You file an appropriate application. I file an application for recalling. That recalling is dismissed because I have not served it prior to filing of that there was a dispute. Again, I come before your lordship. Your lordship held that show your bona fides, take the child to Bombay, meet the father for over
That
a
has been
week.
done.
That has been done. Now, based on that, pursuant to your lordship's order, the recalling is now taken up. In the recalling, based on my averment in the time petition that I taken the child for 4 days, and because the report of the psychologist says it's 5 days, he set aside the report. Now the impugned order directs I'm going to bring the child to Calcutta once every month with the empaneled High Court medical child psychologist. Come here, bring every month, spend time, also do visitation, and bring the child here for counseling also once every month. You know, this is becoming impossible. That the only ground on which that report has been declined to be even looked at is because in the time petition I had written 4 days, and the report says I was taken on 5 days. The gate pass or entry ticket, whatever is there, that was there. And there is nothing with regard to the report.
No, what is with regard to the visitation now?
But what is directed is because I'm bringing
visitation, any arrangement made?
Yes, because I'm to bring the child to a empaneled psychologist here of the Calcutta High Court. Because I'm anyways coming to Calcutta, I will spend 1 day with the father here in Calcutta, either before or after. So the difficulty is, the child is in class 9.
Not even 1 day, only 3 hours.
Yes.
Only 3 hours.
Correct. So I don't have a problem. Well, I don't mind meeting the father in terms of your lordship's order, but bringing the child to Calcutta once every month in either on a Friday or a Monday and miss school on Friday or Monday and on Saturday, and there is absolutely no reason why the
Can it not be done?
So why can't it be done Saturday and Sunday, my lord?
why it can't be done everything because
Instead of the child traveling every month from there to Calcutta.
I can do it with a
So you
Bombay
can-
High
you can-
Court.
you can go there.
Him, I don't mind meeting. This was my
Tell your
case.
lordship, my lord. Now,
problem is
once my learned friend is finished, I'll start.
Only one thing with regard to the child psychologist, there must
There
be
is
some.
a suspension in the mind of the court that is clearly recorded in the order.
Yes,
The only question,
to protect that,
the only question
child
I asked,
psychologist there can be also appointed with
That's
the
all.
same arrangement.
That's all.
With the same
that was
arrangement.
already done. Now, my lord, only one question.
Only one thing.
One
bringing
question.
The child.
But I'll show from the pleadings as well.
I can go to Bombay. I can, if your lordship desires the Bombay. If this psychologist was not our choice, and the report of a medical certified professional has been disregarded. Why? Because in my time petition, I've said 4 days. The report says analysis for 5 days. Don't say no. 1 second. That's there in the impugned order. My only thing is, if there is any doubt, I don't have a choice of doctor. The child interacted with the judge. In fact, I can, if your lordship desires, I can have the child come and meet your lordship also. The child is not a child anymore. He's 12, 13 years old. So he has a mind of his own. I can have somebody from Bombay High Court empaneled. And this arrangement that your lordship has directed.
I'll give my reasons. Well, I'll give my reasons. Lord, now kindly have a look at his pleadings. What your lordship is looking at, always looking at, is the paramount welfare of the child from day one. My lord, kindly comes to page 7 of the application. Lord, his own pleadings, my lord, not my pleadings.
Yes, how much time both of you will take?
I have no
Come back at 2 p.m.
5 minutes.
I have fixed one matter at 1. It has been postponed twice today. It was taken up at 10:45, it was postponed to 12, then to 1.
No,
That
I
is
don't want
why.
to interfere with your lordships.
That is why, can you come, any
Okay.
difficulty to come at 2 p.m.?
Instead of 2, can it be on Monday?
Yes, I have no issue.
Monday kono. Oh, but let him not file a contempt in the meantime.
No, 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 no.
Come at
Why
2
should I-
p.m. You
why
have
should I-
difficulty in 2 p.m.
Today 2 p.m. I'll be in some difficulty. If I
But
can
if I
come on
only can
Monday,
continue for 2 minutes just to show these 2 paragraphs, because it's a question of paramount welfare, my lord.
No, but
He's arguing.
I have to dictate the orders also. We'll
No, no,
take some
Zorkore kora,
instead
sir.
of Monday,
2 p.m. Mr. Banerjee, you have made your submission. So you
but without me, it'll find it slight difficult. My lord. Today, only today at 2 p.m. I have some difficulty. If I could just.
How long it will continue?
10-15 minutes, not more than that for me.
No, not in this matter, in the other matter. Or you will be leaving court.
I will be leaving. Lord, I have a slight issue with my back. I'm finding it difficult to stand. There's
No,
certain MRI reports
Monday
that
will be
come,
convenient for me as well because I have a circuit based
Let
matter
him
at
not
2
just
p.m.
file a contempt because
Why should I?
then it's fine. Lord, Monday.
I want to end this issue, my lord. What I today really want.
Let the matter retain its position. একটার সময় যেটা রেখেছি। Yes, call the 1 p.m. matter.
Number 12.
Yes, Mr. Banerjee, why did you not appear when the matter was taken up?
Matter was going on. I'm tendering my apology, madam.
Somebody should have been present.
My fault.
Mr. Ghoshal was waiting.
My fault. I can't say anything.
Yes, Mr. Banerjee, what?
I said my sorry. Ask for forgiveness from Mr. Ghoshal. He's not.
Most officer tolerant. No problem.
He has forgiven you before you have appeared. Yes. Yes, Mr. Banerjee, what?
218 applies in my humble submission. 218 says, my lord, if dies without any will, then any person who would be entitled to the estate can apply.
Yes.
So, possibly even an application under section 218.
This is not in dispute.
No, that is not in dispute. Now, Mr. Banerjee, please take up the impugned order once.
My lord.
Now, the impugned order says that this is a letter of administration in respect of a bank locker.
Bank locker.
Being situated in such and such,
That means
the petitioner did not apply for inventory of that locker and no inventory report was submitted before this court till date. Whether it's necessary, because at times you may be.
307 is the answer. 317.
317, yes. Inventory and accounts.
And then after the will, when
Yes,
is granted,
After
then
after. And even if your submission is accepted, inventory may be for the purpose of court fees.
Whether properly
You-
administered, whether properly administered by the administrator or the executor.
Yes,
There are no executor because no property is there.
yes.
And administration is LA only with not with a copy of will annexed. This is not a copy of the will annexed.
So this inventory and accounts will be after this.
6 months.
Yes.
within a period of 6 months.
After the grant of probate or letter of administration.
That stage has not come yet. No
The 18
application.
minute, my learned senior friend was showing a judgment. Sorry, was showing a judgment to me that court will only look into whether there is a property or not and whether somebody who is claiming has some relation
Judgment.
to apply under 218. Title cannot be gone into or what.
My lord knows it. This is elementary thing.
Asking for letters of administration for administrating the estate.
This is abundant precaution that we are carrying it.
No, Mr. Ghoshal, it's
paragraph
good sometimes to recapitulate something.
Because unless there is a will,
Paragraph
there
13
cannot be
will.
executed.
Yes, which paragraph
Paragraph
you are
13.
relying upon, Mr. Ghoshal?
13.
Which paragraph?
13.
1-3.
Head note is also clear. This paragraph 13 is also clear. Inventory is confused with 39 rule 7 of the contents of the locker.
It is not necessary for the court to decide what assets are likely to come to the hands of the applicant for letter of administration. Court is duty bound to consider whether there is any estate at all to be administered. Need not specify whether any property was left by the
That is the locker. Locker is the not.
locker. Existence is there, and inventory, the reasoning is inventory has to be after the
Locker is the property of the bank. The locker is the property of the bank, but they have a right of operation. That is
Yes.
not
On payment of rent, they will
For that, only for that he wants this LOA. Otherwise, he will not be allowed to operate.
right to operate the account, locker,
Locker.
on payment of rent.
On payment
That is
of
the
rent.
only contractual obligation with the banker and the customer.
দেখে দিন।
Passover matter 20.
Yes,
Malad, item number 19 to 22, all are similar.
19 has been
Yes,
disposed
yes,
of.
your lordship has been pleased to dispose of this matter.
Yes. What is 20?
Your lordship, may I submit, your lordship, what has happened, your lordship? The respondent herein has taken a loan from us. We are a finance company, he has taken a loan from us.
What are you challenging in?
I am praying for an expeditious disposal of an application under section 5. My lord, kindly bears with
When it is fixed for hearing?
your lordship, please number lordship, may I?
When it is fixed for hearing, please give me the date.
Your lordship. Lordship, kindly bear with me first.
Or
3rd of December 2025, your lordship.
12th of?
3rd of December 2025, your lordship.
By which order?
Your lordship. On 15 July, petitioner search and search.
This application under Article 227 of the Constitution
It's got a time and again, similar expeditious disposal matter. Has time and again.
section 8 and
Yes,
5.
The matters, what has happened, my lord, your lordship,
Yes.
for once. What has happened, your lordship, in all these matters, I have not been able to file an application under section 11 of the arbitration and conciliation. Every single agreement contains an arbitration clause, your lordship. Until and unless the matter has been referred to arbitration, I'm not being able to proceed with the arbitration clause and
What is
make,
the next date fixed?
your lordship, may I?
9th of January 2026.
Yes, your lordship.
This application under Article 227
Section 37 of the Arbitration and Conciliation Act, there the Honorable Division Bench was pleased to pass an order of injunction. Now, in specifically, Your Lordship, item or 90, the difficulties I have to file because a substantial amount, huge amount is involved. Your
What you have to file?
I have to file an application under Section 11 of the Arbitration and Conciliation Act, but I cannot file it because the suit is pending and the date is fixed.
No, you have, the date has been fixed. I have given you liberty to apply for preponement.
Your Lordship, I've not. If Your Lordship kindly.
I have allowed you to file an application for preponement and directed the Learned Trial Judge to consider it.
If a particular time.
That cannot be done from here. I do not know the diary of the Learned Trial Judge. Yes, call the next matter. Yes.
38 one this matter.
Your Lordship was pleased to fix the matter on Wednesday, Lordship.
Wednesday, along with the earlier matter.
38, Lordship.
Mr. Chatterjee was there. Was informed before Your Lordship that they also filed their tribunal application. Other side is both, sir.
That school.
School
Why are you fighting, Mr. Rai, with regard to the it's the management of a reputed school?
Yes,
Why are
sir.
you
What is
fighting?
that? It is between
Can it
the
not be?
family and the family.
Can it not be solved?
It can be.
So I'm sending it to mediation. Please suggest the name of a mediator according
Let
to
them come and one knows the size, both physically and station, all of the
right. It's a reputed school.
It can be.
I'm saying that you don't. Please take instructions because it's a reputed school. It's with regard to the management dispute, maybe interstate dispute within the members of the managing committee or governing body, whatever name you call.
all are related to each other in somehow.
So if you quarrel amongst yourselves, the
ultimate resultant factor is
sufferer will be the students.
the teachers.
That is
So your institution will only survive
If
because
they
of the
survive.
students. You cannot survive without the students.
Hmm.
So if that is so, and if you say that yes, there is a chance of reconciliation.
So much chance. It is a family matter.
That is why family dispute, if it can be resolved,
Yes, that
you also, all of you, if all of you are represented here, or you can communicate to your other side, you can come with a suggested name of a mediator before whom all of you have, yes,
to the test.
and a person who will be able to tackle this situation. Person of that stature, if you can come, I think it's the best way. You can fight with your legal rights. No
That is
difficulty on
something
that.
else.
Courts have to adjudicate that
on.
dispute one way or the other. But in the meantime, if this litigation continues, Mr. Rai, the students will be the sufferer.
Not the
Please
management.
consider the interest of
Nowadays,
the
why not everything
children,
got to
not
be
your own
uploaded in the
interest.
portal.
Mr. Rai, I'm asking all of you, I'm telling all of you, please don't consider your own personal
That is why
interest.
you can
Please consider the interest of the student.
regular update in the portal for the student. Nowadays, well, it is not for a year. It, every month, periodically, it got to be uploaded in the portal. The portal must be authorized by a person who is the teacher. If she did not turn up, the entire thing or students' interest was.
If that's
something as well, will convey to our clients. Well,
please take instructions because without the instructions
No,
of your
no, no,
client,
no.
you cannot do anything. And also you can communicate with your learned friends who are appearing on the other
and
side.
all the learned advocates
Considering
appearing for the
yesterday's
parties are.
No, yesterday's happening what it was said. I have not looked to the papers. Only thing I can gather, it's an interstate dispute.
Son-in-law,
No,
father-in-law.
that I have also not seen. Between the so now you are saying it's the parties are also related. So if the parties are related, more so you have to settle this dispute.
As a lordship, let matter appear on Wednesday.
Wednesday, let it appear.
With that matter, Lordship.
With that matter.
List
The order is there in the earlier matter, indicating the matter to be heard
along with this. Acha, 38.
38.
Please check up whether another matter will be tagged. Then. Item number 38. This matter was taken up out of turn.
That is.
I will, sir, sir.
আচ্ছা এটা একটা লাইন লিখে দিন
Grateful. Grateful to you.
ये तो
For judgment, item number 1.
In view of the aforesaid discussion, this court holds that the learned DRAT was right in setting aside the order passed by the DRT. The order impugned does not suffer from any infirmity warranting interference under Article 227 of the Constitution of India. CO number 3813 of 2024 stands dismissed. There shall be, however, no order as to costs. Mr. Chatterjee, after the civil division application has been dismissed, can the interim order subsist?
Now your notice not know the police. They will say that the interim order has not been vacated.
This will set a wrong precedence, Mr. Chatterjee. After dismissal, if I say interim order vacated, this should not be done. So you have to make them understand.
Yes, I shall.
And if that is not done, then other. Because this should not be, this will go a wrong signal.
Item number 8.
We mentioned the matter today morning. It was observed by the Malad President that there is no procedure for this transfer to be taken, hard copy filings, and therefore Malad, it cannot be done. If the registry does that, we can have a word with the registry. We went to the Malad learned registrar. Malad, he said that since there is no mechanism provided, I cannot do that. If the president passes an order, then only I can do that. So it's back and forth. It will not happen, my lord. So
Alright,
kindly,
then-
my lord, hears us.
Then I will come on Monday. I will hear the application.
But your lordship, by not issuing the contempt rule, I don't think, in spite of the two orders.
No, why, since lordship is now, my lord, understanding the, my lord, difficulty we face before the, my lord, state commission, I will come back Monday, lordship hears us, my lord, it will be, my lord, because my statutory right
Come
to
on,
reclaim has been, my lord, curtailed.
not today.
My lord, only Mr. Sen, Mr. Shakku Sen had indicated from Tuesday he won't be there. I was seeking, my lord, some indulgence on Monday, my lord, so that in his presence,
Monday under the same heading.
under the same, great.
Yes.
Item number 34.
Yes.
I am for the petitioner.
Yes.
But suit for partition and permanent injunction, my lord. And status quo order is, my lord, was passed, and against the status quo order, my lord, defendant opposite party preferred an appeal, and my lord, stay was, my lord, granted. My lord, kindly see the plaint and the order of the status quo. Now, only page certified copy, page 4, my lord. The petitioner and the defendant are the co-owners. Suit for partition. And
Ground order you are challenging.
my lord,
What is the order you are challenging?
not kindly,
5th of August, 5th of August 2025.
not kindly see, my lord, this order, my lord.
What is that?
The plaint and
No. What is the order which you are challenging? 5th of
what I
August,
stated, my lord.
5th of August 2025.
Yes, my lord. Yes.
Yes.
The defendant are making illegal construction and over the, my lord, best portion of the property. And for that reasons, my lord, partition suit has been filed. The status quo has been passed.
By the order impugned, PM, why? Ma-
From
Your
Tuesday.
junior was apprehensive that will not be available, so he wanted from the morning.
No, actually, he is not available.
Convince your junior.
কি করবে? তুমি যখন তোমার very well.
2 PM will be convenient. তাহলে ওটা 2 PM যেরকম আছে সেরকমই করে দিন। 2 PM ই তো আছে।
I will be in some personal difficulty for the next week from 9. So, I am requesting this one.
Yes, my lord, trial court is liberty to proceed the suit, my lord. Trial court is.
I have not stated, I have only stated the operation of the appellate court's order.
My lord,
Yes,
35
caller X matter.
35 my lord brings short passover, my lord. Mr.
36 দেখি।
Item number 36.
Yes, sir. I have not allowed your prayer for Passover. Where are you living? 35 to.
35 my lord.
Hmm.
Short passover, my lord. Mr. Parthavartim Roy.
He's a busy counsel. Before vacation, you will not.
This matter has already ended, my lord. Just few minutes ago.
2 weeks ago, you have engaged.
Yes, my lord.
And he is ready with the matter.
Yes.
All right, Passover.
My lord.
Yes.
Item number 36.
For the petitioner, my lord. 36. Oh, acha, sorry.
My lord, I'm seeking a small passover, my lord. Short passover because Mr. Piyush Chakravarti is appearing. He is before another court, my lord.
Today we have 3:30. If all matters are passed over,
I believe it is 3:15, my lord, today.
Yes, please start. Please start. He will be joining you.
Maybe,
Yes.
my lord, I don't know. My lord, in fact, this is a matter that, yes, section 6 matter that I have the defendant failed to deposit the arrear rent. My lord, in fact, that I am filing one supplementary affidavit. One point was missing in the petition. May I, my lord, the supplementary affidavit?
Yes.
My lord, in fact,
Please give me a minute.
yes, my lord, in fact, a lot of technicalities involved in this matter. My lord, I'm just, there are two orders that I'm challenging. That is the one order is that 8th of July and another is of 7th of August.
8th of July. Where
My
is
lord,
the order?
that is at page number 23, my lord.
You have not given the certified copy of this.
My lord, that is in the supplementary that I have annexed.
Supplementary, you have annexed the certified copy.
Certified copy. My lord, that was missing for that.
No.
reason that
8th July, you have not challenged, sir.
My lord,
You have only-
that point I have taken. For that reason, that supplementary has been filed, my lord.
Yes, what is there in 8th
My
July?
lord, in 8 July, that is there in the petition also. That is page number 23.
Yes.
In fact, on 8th of July, the Leonard Court has directed the defendant to pay at page number 24, my lord. That is the order part to pay to make the payment of the arrear rent in a single payment on 7th of August, my lord. That is a difficulty. That is on, my lord. There is a difficulty, my lord. And for that reason, that on 7th of August, my lord, in fact, that order is there, my lord, the order is there, my lord, at page number 14, my lord.
Page number?
Page number 14
of the
petition, my lord.
Yes, which order?
That is the 7th of August, my lord. Order number 62. Miller, on that day, unfortunately, that I have been directed to deposit the arrear rent on that particular date, not prior to that, my lord. That is a difficult. That is the difficulty, my lord. One more thing, my lord. The thing is
There is
that
a great difficulty for you.
my lord, the thing is
On a
that
particular date, not before that.
Miller,
So you are ready to pay before that.
not Miller, that I would have. I cannot because I have been instructed to make the payment on that day.
Yes.
So Miller, the difficulty is that on 7th of August,
Yes.
when I came up with the money to the court, the advocate who was appearing, Miller, that advocate, I believe that the medical certificate is there, Miller. The father-in-law of the advocate, he suffered a stroke. For that reason, the advocate has to rush. He has only given the hajira. Then after filing the hajira, he ran away out of that, along with the money that I have deposited, Miller. For that reason, Miller, that I have annexed the photocopy of the bank statement showing that on that particular date in the morning that I have withdrawn from the ATM counter the money. I came with the money and handed over to the advocate, but I cannot. That could not be deposited. For that reason, that my defense has been struck down. That is the only difficult, Miller.
There is a great difficulty.
Milord, that is the order. I have been directed in that way, Milord. I cannot even, for that reason that I am challenging both the orders, Milord.
Did you file any application for extension of time?
Extension, no, Milord. Then after I could not.
Why? Why you could not file an application for extension of time?
Milord, immediately thereafter.
7th of August is only 1 month. So the proviso gives you 2 months. What prevented you from applying? From
The
putting
problem
it
is that, Milord,
on that particular date, he was not available. You could have
Milord,
applied
the
for
problem is
extension.
that this is the second extension. This is the extension period that was given on that day. Prior
The
to that,
extension period.
Milord,
What was the original period?
the original is of 8th of July.
No. 8th of.
Milord, that is page number.
Show me the order disposing of 7-2. Where is that?
Milord, that is at page number 20. That is the order dated 9th of June 2025.
Oh, 9th of June.
Milord, in that order, at page number 22, in the ordering part, that the defendant is hereby directed to pay an arrear amount of in a single installment to the plaintiff within a period of 30 days from the date of passing of this order as per the provision of section 7.
What happened? Why you did not deposit within this time?
Milord,
it was within a period.
Milord,
It was not on a particular date.
Milord, for that reason that the order is there at page 23, Milord, I have prayed for that because of my client is a small businessman. He's only running a ticket booking counter there. That is the private ticket booking counter, my lord knows. For that reason, he could not arrange this 26,000 of money, and he has only prayed for that. And in that order, he has been directed to pay on that particular date. So that was the difficulty, Milord. The technicality is this only.
Yes. Anything more?
Milord, for that reason, Milord, I know that Mr. Piyush Chaturvedi, he will
be able to convince.
He may, Milord, because some technicality involved, and it's a small businessman.
Where is he?
He is before another court, Milord, actually.
Ask him to come at 2:30.
2:30, Milord.
Yes, pass over.
Call
the next matter.
Item number 37.
Before that, my lord, my lord, 43 items. My lord, I have fixed 5 rooms. Case something and vice versa. I use the Roxy around 43 items.
43?
43 is Roxy. But by this time, my lord, it's a matter of demolition. My lord, I have charge bills that code number 41.
Where is your junior? Ask him to stay here. You can go there. Yes.
I'm for the petition, my lord.
Yes. What
My
is
lord,
the
this is a suit for declaration and permanent injunction. It was filed in the year 2011.
Yes. What do you want?
My lord, I am against an order of Order 6 Rule 17 application, my lord.
Yes.
Which was sought
rejected. Order 6 Rule 17 allowed or rejected?
Allowed, my lord. I am against that. I am the defendant.
What is the miscase for?
The miscase is for filed at their instant. It was for an application under section 10 of Code of Civil Procedure, my lord. My lord, that is being the contention. The main hearing is being called.
The order you are challenging, which order you are challenging?
Order 6, Rule 17, the last order.
Order date.
Order date is 10 July 2025, my lord. Learned Civil Judge, Junior
Your
Division.
date has been fixed for hearing order 6 Rule 17.
Yes, my
It has
lord.
not been rejected.
It has not been rejected, my lord. We have moved an application opposing that. But my lord, that was not, that has been turned down, and my lord, the date has been fixed for hearing, my lord.
Yes, only a date has been fixed. How can you be agreed by that?
My lord, may the main petition be heard first. My innocuous prayer before your lordship, may the main petition be heard.
What is the main petition?
The main title suit, my lord. They are just circumventing the situation.
Has to be disposed of first. This application.
Yes. 39 is not my application, but it's arising out of a commercial forum dispute, by the order impugned, order number 42.
Yes, yes. What is your instruction?
The instruction I have taken, they are not capable of depositing the sum. So that I have to argue it on merit. So that I am showing the order impugned which I am challenging. My application under nature of section 47 have been dismissed in this manner.
Yes.
Kindly see the order. This is the order.
What is which order you are challenging?
42, no?
20th of March 2025.
20th of March 2025.
Yes.
This is how my application in the nature of section 47 has been dismissed. I'm reading it. Learned advocate for the judgment letter is present. I am present. The decree holder is not present. MA application 347 and 348. These are those applications for maintainability of the execution proceeding in the nature of section 47.
Two applications filed by you.
Yes, I'm challenging the
applications.
But basically, we had the one application, other one was subsequent, challenging the further orders. So mainly 347 is taken up for hearing, heard, considered, peruse the content of the MA application and the judgment referred by my advocate and arising out of which and such. Peruse the order of appellate court submitted by learned advocate for the judgment letter and prayer of the judgment letter made in both MA case. The judgment of the appellate court set aside judgment in CC and such, not the judgment of CC 280/2017. Thus, we find no application of the judgment letter
judgment of the appellate court in the present execution case since the same.
Where are those applications? 347?
Yes, Milord.
Which is the effective application?
Milord, I am showing that. Milord, 115, page 115. This is their application. MA number 348. Lordship would take at the left hand side corner top. Yes. Paragraph number 4, Milord, I have given these circumstance and Milord, ultimately I have raised the point of maintainability at paragraph number 7. Education matter cannot come under the purview of Consumer Protection Act. That's the point of maintainability. This point I had also raised before the Honorable Supreme Court. Supreme Court kept this point open and disposed of my SLP. Actually it was withdrawn. Okay, maintainability point was kept open. I raised this point, maintainability point, before this forum.
Please give me a minute.
Yes, please. Supreme Court. Yes, now that this point I had raised for the Honorable Supreme Court earlier, page 112. Although the SLP was withdrawn, the question of law was kept open. After that, this is page number 112, 24th January 2020 order of Honorable Supreme Court. Lordship would take the names of the parties, Milord. I was petitioner for Lordship was the appellant before the Supreme Court and the opposite party, Milord, was the respondent. Now, Milord, in view of this order, I filed this application challenging the maintainability point, section paragraph 6 and 7. It's an education matter. It cannot come within the purview of this act. Milord, then I have shown the impure order, Milord. That's how the application has been disposed of. Without, there is no adjudication at all.
How can it be now taken?
But because the Supreme Court had kept that point open, question of law is kept open.
Maybe.
I'm not the execution case.
And where is the order of the National Commission that this?
Yes, I have annexed it. It's annexed.
So that order was passed subsequent to the order passed by the State Commission.
Yes, Milord. National, Milord, I would
that
say
be a ground?
One page,
subsequent order, can that be a ground?
No, not subsequent order, Milord.
That is, show me when the order was passed by the National
I have annexed it. Page 111. These are not orders on merits. I had kindly see the order, Milord, of the National Forum, Milord. After some arguments,
that this education matter do not come within the consumer protection. Show me where is that order?
That point, point I am taking for the I have taken for the first time for the Honorable Supreme Court.
No. You have said before the National Commission also. Please kindly come to your application.
Yes, paragraph number 6, Milord.
Yes. So where is that?
No,
that the judgment data begs to say that the order passed by the District Commission, State Commission, when the special bench decision of the National Commission declaring, where is that special bench?
These are references, not relating to this matter. In other matters,
show me that.
No, I am carrying the judgments of there are two Calcutta High Court judgment and one Supreme Court, particularly on this point that education cannot come within the purview of this. I am citing that, and the National Commission order also I am carrying. I have cited these in the for the court below.
Yes.
And this is the special bench of National Commission. Page number, paragraph number 10. Specifically, this point was decided. 1991 1, 2011 SCC double. 1991 SC 1, 2011 12 SCC, 2010 volume 11 SCC.
Yes, where is the order passed by this court, this honorable court?
Yes, Milord. This is Milord, our court's order, Milord. 1991 SCC online, Calcutta 241, paragraph 28. Sir, may I, that is a marked copy, Milord. Kindly keep this receipt on this copy. And 12 SCC.
Paragraph?
Paragraph 28, Milord.
You contested the complaint case.
I have contested complaint case. There is no, I am not shying. I am only saying, first time question of law I am entitled to take, Milord. I have taken before the Supreme Court. Court said the point is kept open. Please go back. I went back, took this point, not decided. An application has been dismissed. This is categorical.
Show me your written version in the consumer complaint case.
Yes, Milord. I'll show, Milord. Complaint,
that point.
I have not, Milord. It's from the complaint case itself will come out that it's a educational complaint completely. Milord, it's attached at page 70, Milord.
17.
Yes, I am also carrying a Supreme Court on this particular point. Milord, what followed, our court also will have followed the same point.
Yes.
I kindly read my name in the page 17, Milord. The respondent's name, opposite party name is Global Institute of Fashion Technology. I am an institute. The paragraph number 2, complainant says that in search of institution which is well inclined for providing degree course, BSc, Fashion Technology and Designing, which includes internship and placements. The complainant says that she was provided a brochure and was given information that the institution is affiliated and holds a goodwill, and I am not reading that paragraph.
Where is that? It is a charitable educational trust. Where is that?
The question of education.
No. It says, yes, please kindly come to the National Commission's order.
I have shown that our High Court's order, paragraph number 28.
Yes.
That if I am permitted to read it once, Milord. In view of the matter, I hold that education does not come within the purview of Consumer Protection Act. There is a straight bar on education matters. That this is prior to the special bench national forum, Milord. Supreme Court paragraph number 4. Paragraph.
Where is the
2010 volume 11. That exclusion is not there anymore in the.
Admittedly, yes. Paragraph 9 of the National Commission's order.
Yes, National Commission order says that. Like I have seen.
View of the above settled position of since the respondent is a charitable and educational trust.
In this matter, yes, Milord, but Milord, our High Court judgment and the Supreme Court, Milord, does not say. It says if it is education.
The Supreme Court judgment.
2010 volume 11 SCC, page 159, paragraph number 1, 4. Kindly read the paragraph 1. That's the dispute. Then the paragraph 4 and 5 and 6.
No, the National Commission, that's a different thing.
That's
There, no, before the our Supreme Court, it held that the board, the examination board, it's a statutory authority.
paragraph
It
20.
does not offer paragraph 20.
Paragraph 20 is the case by which,
Yes.
so in
So
that
it
case,
was held, it's an examination board, it's a statutory authority, therefore it cannot offer service.
in that matter, my lordship is going into the facts of that case. I am saying that following
There
that,
is nothing which says, yes, any institution cannot offer service.
no, but that paragraph 28 of our High Court judgment,
Yes.
1991 SCC that's a case of civil revision, the judgment of civil revision application. They are not
Give me a minute.
categorically says that in view of the matter, I hold that education does not come within the purview of the Consumer Protection Act, and no district forum under the Act can entertain any complaint.
Please give me a minute.
অন্য সুপ্রিম কোর্ট অ্যাপিল করতে I would request Lordship to read from paragraph 11 onward.
Please give them. What is the dispute in this case?
In this case, my lord, the petitioner says that when he took admission, she thought that we had sufficient registration with our parent body. Ultimately, when she was about to pass out, she realized that our registration had already lapsed in the meantime, and therefore we could not give her a proper certificate of passing out. That's the complaint, and that's how the case has been made out. This particular point, in fact, Justice Bhattacharya's order is also there, saying that education is not a commodity. Another application arising out of the writ petition. I'm carrying that as she can look at the paragraph 9 of the judgment, our High Court judgment, Justice Bhattacharya's judgment.
The learned advocate appearing for the petitioner submits that
Item number 36.
yes.
Sir, my lord has seen. 7-2.
So your junior assured that he will try to improve the case.
I can only make an endeavor.
Yes.
Lord,
Yes.
Page 22, Lord, kindly see the order passed on my 7-2 application. Lord, the amount determined and directed to be deposited within. The word used is within. Lord, I am unable to Lord, I make an application. Then, Lord, the order which is
You
passed,
made an application for
Lord, seeking exercise of discretion under the proviso to Lord 7(2). Lord, my Lord knows, Lord, once only 60 days. Lord, 30 days granted, although the court is satisfied with my
30 days, yes, 60 days is from the parent order.
Now, kindly, Lord, see-
Because it cannot extend 2 months from the date of adjudication.
yes. Now, kindly see, Lord, on a particular date. On.
Sir, Mr. Chaturvedi, on a particular date, if that was there, what prevented you from bringing to the notice of the learned trial judge? Yes.
I did that, but this is what I'm saying.
When did you do that?
On the same day when I received the order, Lord, I mentioned the matter before the court, which is my pleading. The court said that you have to deposit it on that day and file a challan. Hence, the word within is not there. I only sought modification that instead of on, kindly make it within so that I can deposit within such date. That will not compelled me to withdraw the amount on the same day and give it to my advocate. But I gave it to my advocate. But he had a medical exigency in the family and filed a hajira, but had to leave court. He could not deposit it. But I only indicated not 2 pages. Not kindly not see.
Mr. Chaturvedi, now what case you are making, it's not really on or within, because your case is that you came on that date. So nothing boils down on that expression on or within.
No, on. It was.
Yes, but you went on that date. So it cannot be extended after 7th of August or 8th of August, whatever it might be. It cannot be extended after that. That's the outer limit.
That is what I'm saying. Lord, 7th August, when I went there, Lord, I gave the money to my advocate. Now, the advocate filed hajira. He had a medical exigency, so Lord, he could not. I am saying, I am challenging both the orders, 60 and 62.
Mr. Chaturvedi, I cannot go into that intricacies here. You have to file an application there. How can I go into that? Whether you have given, those are factual things.
No,
Mr. Chaturvedi, those are factual things. Nobody knows whether you have ultimately paid to the learned advocate, yes, no, nothing on record to show that.
I am challenging both 60 and 62. 60 says on.
60 and 62, Mr. Chaturvedi, you are saying it's on. Maybe it's on, but now if it is not within, then you are also out of time. Because on your case is that on that particular date, you are ready. So if on that particular date you are ready, now you cannot say that earlier I could have done.
Lord, on that day, Lord,
So you accepted that order. Where you are saying that yes, you are ready to pay deposit on that particular day.
I had no other option.
Yes, so you accepted that. Rightly, wrongly, whether you had many options or you had only one option, you have accepted that option. Now your case is that, yes, you are went to the learned advocate, you have paid him the money, he did not deposit. Mr. Chaturvedi, where is that case made out before the learned trial judge? Show me that.
Lord, kindly see the medical prescription of the advocate's family.
Show me what was the, where that case was made out before the trial judge. I cannot for the first time decide on that factual aspect.
That case, on that day itself, Lord, since the challan was not deposited, Lord, 7(3) order was
It was for whose fault, nobody knows. It requires an adjudication on facts, Mr. Chaturvedi. Whether you had actually given, whether your client, advocate went, those are factual issues. Can that be decided, factual issues, in 227?
By seeing page 28, will my Lord kindly grant me that liberty? By seeing page 28.
Yes.
Kindly see page 28. This is a medical prescription. Will my Lord kindly grant me the liberty to approach the learned trial court? It is, Lord,
Where is the case made out that you have handed up to the advocate? You have paid the amount to the advocate?
Lord, page 25 is not the withdrawals.
Withdrawals is another thing, Mr. Chaturvedi. You may have withdrawn from your bank account. You may have gone somewhere else to spend that. With your friends, might have been. With your friends, you have spent it times.
Thereafter, my Lord, and thereafter by application, thereafter I did not get any opportunity to file an application before the learned trial.
Chaturvedi, the lawyer does not deposit these amounts.
Lord, the clerks, Lord, but then
Clerks deposit this amount. So that is why I'm not going into that. So you know, you are the best person who deposits before this. So it's not the advocate. Advocate does not go there to deposit.
But this is not
This is one thing.
This is Chandanagar. Chandanagar.
Wherever it is, advocates do not go there, Mr. Chaturvedi, to deposit. And when on that particular date, the learned advocate also attended the court. Maybe he had left, Mr. Chaturvedi, maybe he had left, but he was so much diligent that he filed Hajira also on that date. So he took all responsibility, he took all steps.
Yes.
So it's very difficult to believe that that learned advocate who was so much responsible will take the money with him to attend his father-in-law in a hospital. Very difficult to believe.
But Lord, fact, Lord, will my Lord kindly.
Because these are factual things, Mr.
I
Chaturvedi. You have not made any application before the learned trial judge with
Sir,
regard
because
to
I
that.
suffered 7-3, my Lord, I could not have made any application
Because
there.
that's the consequence, Mr. Chaturvedi. Nothing, it's automatic. Once you fail, you fail.
Until my Lord grants me that liberty, Lord, I cannot even make an application on the basis of page 28. Kindly grants me a Lord liberty so that I can approach. I leave it to the conscience of the learned court below. Will consider.
Where is the statement made in this civil division application that you have paid this money to the learned advocate?
Page 7.
Paragraph
19, 20 and 21. And the learned advocate is ready to affirm an affidavit to this effect. It is he only, my Lord, who has given this prescription, or else how can I get this prescription?
No. Mr. Chaturvedi, that's
He is ready to affirm an affidavit to this effect. If my Lord grants me this liberty, I shall make an application along with an affidavit of the advocate.
this application under Article 227 of the Constitution of India 35, yes.
An application or order of rooted in a suit for partition has been rejected.
For partition, rightly, no unity of title and possession.
My case is that they are not related with this property, but
They
in
are
the related with this property, but the names are appearing in the record of rights. For abandon caution, I have made them. I want to make them party to avoid all this because at the time of evidence,
If your case is that they do not have any right title and
there is a
possession,
specific case. My lord, if your lordship will consider,
on that,
if ultimately my lord it appears they have semblance of right, because why my lord your lordship find
Mr. Rai, then you have to, you cannot take a chance in that way. So you have to make a positive assertion that there is unity of title, because who are the necessary parties in a suit for partition? Those who have a semblance of interest in the property and there is unity of title and possession. If you say they do not have any interest in respect of the property, then on such averment, it cannot be allowed.
I bow down to your lordship. Now, my lord, this came up from consideration. If a parcel is in possession, under what capacity, according to me, he has no right title interest. Their names of fishery, my lord, that is why I can turn to page 31. Right hand column, my lord, you will find
page
31.
Yes, 31.
Right hand column, my lord, Montobbo column, my lord, got it.
Yogesh Sarkar,
Yes.
Unumoti dong.
That is what. Now, my lord, it is for the purpose of 30. The same thing.
Unumoti dong, Mr. Rai.
Precisely, my lord, that is why I can turn to my application under order 110. Apropos to this. Page 34.
Page
34.
Yes.
Paragraph 2, my lord, will find why I have intended to make the party, but could not collect the deed. But till today, their names are recorded in the Khatia number 7.
What is the deed?
The deed, some of the names are there in the record of rights as a Unumoti dog, but they have the title deeds with them. That is why, my lord, can you try to collect the deed of
this whom you wanted to add?
Yes.
Where are the particulars? These persons.
Yes, 35, your lordship. Because Bhutu Adhikari, my lord, and Nitai Sarkar.
So many persons.
Yes, they are the sons.
Recorded.
They are the sons and daughters of these persons whose names are recorded. One can consider the Panchanan Midda, Koko Midda. That your lordship will find.
Sir, best thing, withdraw the suit, file a press. Everything will be changed. Shares, if you say that yes, because you have to say they have, unless you say that they have title, cannot be added.
Partition presupposes they have unity of title at least.
So you have to pay for declaration of your share. So you have to ascertain your share.
Yes, I can ascertain, but this is my share. Whether I'll get it or not.
So everything. This
now, I can consider the plaintiff.
Withdraw the suit, nothing remains. Withdraw the suit, file a fresh suit.
Well, can turn to the plaintiff once.
Yes.
I'll turn to page that 14, paragraph 5.
Paragraph 5. This is a plaint.
Yes.
Yes.
Your lordship find paragraph 8 that at present Ashim Kumar Adhikari, Bhutu Kumar Adhikari, Gautam Adhikari, and Bhulia Sarkar have no interest in the property, probably, my lord.
In the property in this, all right. So let us.
The entire suit properties have been possessed by plaintiffs and all the defendants, but the plaintiffs.
So that is your positive case.
That this is why, my lord, I have very submitted to your lordship that this is my case made out.
So if this is your case made out, that's the contrary case which you are trying to make out in order 1 rule 10.
That is my case is that
your specific case is that excepting plaintiffs or the defendants, nobody has any title.
That is why, my lord, I have categorically mentioned that though they have no title, but their names are necessary.
If you say yes, they are necessary parties, withdraw the suit, file a fresh suit. Nobody is stopping you from that.
If they are added in the
cannot be on this.
If they added
is your This is your positive. Show me your application. What have you stated
Yes.
with regard to interest? Why you want them to be added? Show me.
Paragraph 2. That is the only thing, my lord, I can submit.
Paragraph, page 34.
Page 34, paragraph 2. This is the only things.
No, nothing.
This is the only thing which I mentioned.
Nothing. What is the reasoning of the learned trial judge?
What is followed from your lordship?
Then I'm bound by the trial court's judgment.
Can you turn to the peruse the pleading? And there is, but the reason assigned to that extent is no amendment has been filed along with the application for addition of party. That is one of
Trying to give some additional reason.
addition. That is
application of-
the reason which have been given is followed by lordship. But the court is of the opinion that without amendment of plate, how they can be added because there is no cause of action against them.
And in the written statement, any objection with regard to non-joinder?
That your lordship will find, your lordship can turn to page 17 once. Counterclaim along with
Yes, any
paragraph 5. Page 17, paragraph 5.
Oh, that's the general.
That is the general. Apart from that, my lord, your lordship will find.
But your positive case is that accepting plaintiff and defendants, there are no one.
And Badi Arji Bodhito Jotha.
And in the evidence what you have stated, we only have interest. Has to be.
Yes, that my chief pilot in terms of the plate. Chief will be pilot the cut copy paste of the
Not the chief, maybe in the cross.
I don't have probably pilot this that. Otherwise, all of the pleadings will be.
This application under Article 227 of the Constitution.
And 41.
40 and 41, yes. Yes, Mr. Chatterjee.
Lord, it is that matter, my lord.
Which matter?
My lord has heard it. My lord, I must say, my lord, admission, judgment upon admission, my lord, my case is, my lord.
Judgment on admission.
My
What
lord,
is the admission?
my lord, my plaint is, my lord, father died. The tenant now, my lord, the legal heirs. 2G has come into force. 5 years have gone. So, my lord, that is being admitted by the defendant, tenant.
So this is in another suit. They have admitted.
They have admitted. And my lord, Mr. Rai was as all.
So what did you do?
My lord, Mr. Rai has argued on similar line. My lord, he has relied upon a.
What have I done?
That has made a CAV, but he has relied upon a decision of 2025 SCC Online SC 751, where the on 2G, my lord, on admission, my lord, decree was granted. On this admission, that
So the plaint.
It requires hearing, my lord.
No, 2G, the judgment of the division bench which Mr. Raj cited.
No, these are Supreme Court, my lord. And my lord, our court has also one I have cited, my lord, Justice Shorkar has granted that.
No, here.
Jetale.
No, that 7172 was rejected.
No, my lord, thereafter, my lord, from 7172 court is inferring that you are admitting. So therefore, finally, my lord, court says, my lord, decree to be granted.
Where is that? Which paragraph?
Yes, my lord, kindly, my lord, court discusses about, my lord, paragraph 11.
So what is your suit, Shobi?
Yes. My lord, my case is also on similar line, but my lord, facts to that, my lord, I will just only indicate.
Where is your plaint?
Yes. Kindly turns to plaint, my lord, page 15.
Plaint.
Yes, it's annexed. Page 15 is my plaint. 15, 1-5.
Page 15. Oh, no, Tabodana.
My lord is. So
there are two matters.
No, my lord. The other matter, my lord, is because two suits. My lord, in the other suit also, same line of decision has come. So, my lord, that has also been challenged. That revisional application. My lord, has got plaint, my lord. Page 15.
So you have filed a suit on 2G.
2G.
What is their admission?
Now, my lord, if my lord sees my plaint, my lord, paragraph 4.
No, show me. Your plaint is that you have filed a suit under 2G.
Yes.
Show me their admission.
Yes. Now, my lord, their admission would be coming, my lord, from the other suit which they have filed. In my suit, my lord, what they have denied is, my lord,
Yes, what is their suit?
Yes. Kindly takes up page 53.
53 is the application under order 1226.
Oh, sorry.
You are not ready to the Mr. Chatterjee?
No, 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 the page number. Page 37.
Is it page
37? 37. 37.
No, is it page 41?
No, my lord.
Is the pair in that page 41?
Page 41.
Mr. Chatterjee, how can it be an admission?
Yes, that's why I say, my lord, in the pleadings.
You say, Mr. Chatterjee, that 2G, he is a trespasser. He files a suit claiming declaration of tenancy right. How that can be an admission?
But
he is trying to set up a tenancy.
Absolutely. My lord, if he sets up a case of a tenancy, my lord, on what basis? My lord, he says in his pleading that yes, my father died. Father was the original tenant. I inherited the tenancy. I am continuing with the possession. So therefore now declare me as a tenant. He doesn't set up an independent case of tenancy.
The father was a tenant, and now after the death of his father, the plaintiffs have become tenant under the defendant.
Yes.
As a right. When did the father die?
Yes.
Where is that admission?
Yes, yes. My lord, on the last occasion, my lord has our case is, my lord, in the plaint.
No, not
father,
your case. Their case.
Because they do not
an admission.
They are not saying, my lord, the date of death. They are admitting the death. My lord, in our plane, we have mentioned the date of death. That is 6th of April 2015.
So there is
And
no
my-
admission, Mr. Chatterjee.
But this is a death certificate. How can you deny death certificate?
That can,
My lord, death certificate cannot be denied. If he is not,
where is that case, where you have stated how he has been, he has dealt with regard to that? You have given a specific date of death.
yes,
of the-
that is paragraph 5 of my plane, page 17.
Paragraph 5 of your plain touch.
Page 17.
Yes, 6/4/2015.
Yes.
What is their reply
Yes,
to
now,
this?
my lord, in their written statement, what they say, kindly seize. Paragraph 5 chilo na. So with regard to paragraph 5,
yes,
they have answered in paragraph 9,
page
23. That is the written statement in this suit.
Paragraph 9.
Raja Ram Shaw is the father, has died.
No. No. Averments, it is false to say that the tenant Rajaram has died on or about 26/4/2015, and since then the defendant claiming to
Yes.
is unauthorized. So they are disputing this date.
You are disputing the date, not the death.
Not the date, but the date.
Now, my lord, if the death certificate is before the court, my lord,
Yes.
and he is not specified his father, it's not my father who has died. My lord, kindly appreciates. My lord, he knows when his father died. So, my lord, evasive
He does
denial.
not know. It's you who knows his father's death. That's his case. You are saying
that if I know,
you are saying his father died on a particular date. He says no. So that shows that you know, but he does not know.
Now, if my lord, I know, my lord,
He does not know.
he doesn't know, my lord. Let the state be taken, my lord, on record 6th April, and there is a death certificate.
So you are admitting your own case on that judgment on admission.
So, my lord, what happens, my lord? I have relied upon a Supreme Court, my lord, which says 2010. If even in specific denial cases, Honorable Supreme Court is saying, if you do not deny, which has to be denied specifically, which will not tantamount to admission.
That is the Order 8 Rule 5.
Yes.
Order 8 Rule
About
5.
this,
Even in a case of admission, court can require the admitted facts, Mr. Chatterjee, well settled, need not be proved. So non-traverse, doctrine of non-traverse, if certain plain allegations
on non-traverse, my lord, Supreme Court is saying
also admission.
Also admission.
Yes. So also on admission, so doctrine of non-traverse, admission. So even then, the court can say, ask the plaintiff to prove that, or the party to prove that.
Will not make because the object will not has been discussed by Honorable Supreme Court of Order 12 Rule 6. Will not why to protract a litigation when it depends upon
That is
not
the
one
other
type.
side.
Will my lord has not directed me to serve. That's why listed motion 1 second.
I have not directed you to serve. So you had a very bad case on that.
Will allow me to serve and come back because it depends upon one death certificate.
That order could have been passed on the first day. So now I have forgotten something.
Well, may come back because I will recollect my lord's memory. But my lord, if in the meantime my lord directs me to serve, have come back, I will come back. My lord, only thing, my lord, I would say the object is, my lord,
to Order 12 Rule 6 rejected.
Rejected. My order is bad. That I can say. Court has said I will not look into that. His plane.
By the order impugned the application under Order 12 Rule 6. These two then civil division applications are
Will
to be heard
attack
together.
together.
দুটো একসঙ্গে
Right.
করবে।